Production of the registers was lawful, effected pursuant to a court order, and necessary for the just determination of the inquest. The respondent emphasizes that inquests are inquisitorial in nature and aimed at establishing the circumstances surrounding a reportable death, and that the court is empowered to call for any evidence necessary for that purpose. Further reliance is placed on Section 7 of the IPOA Act and Section 173 of the Evidence Act to submit that the court acted within its powers in directing production of the registers. It is also submitted that the applicant admitted under oath that all entries in the registers were made by him and that none had been altered by third parties, thereby negating any claim of tampering. The first interested party, that is IPOA, did oppose the application and submits that the applicant's claim are factually and legally untenable. IPOA emphasizes that the applicant testified on oath, confirming that he personally made all entries and corrections in the arms movement registers and that no tampering occurred. It is submitted that the applicant did not object to the production of the originals on the grounds now raised and cannot approbate and reprobate. Reliance was placed on the case of Banque de Moscow versus Kindersley, second edition, All England Law Reports. The first interested party further submits the provisions of Section 80 to 82 of the Evidence Act are inapplicable to inquests, which are governed by Sections 385 to 387 of the Criminal Procedure Code and are conducted under relaxed evidentiary standards. Reliance is placed on the case of Macau Musau, 2024, in law reports, Morris Ndo versus Kinywa Mwelenga versus Republic, and Kemei versus Director of Public Prosecutions and another, to support the admission of original documents for purposes of scrutiny. IPOA maintains that the registers were lawfully obtained pursuant to a court order, preserved under a proper chain of custody, and produced to facilitate a transparent inquiry. It is submitted that the applicant has not demonstrated any prejudice and that the application is intended to delay the inquest. The second interested party, that is the family of the late Rex Kanyike Masai, did oppose the application and submitted that the ruling of 3rd of September 2025 was proper and within the court's inquisitorial mandate under Section 386 of the Criminal Procedure Code. The family submits that the arms movement registers constitute primary evidence central to establishing the circumstances of the deceased death and to the right to know the truth. The family contends that the applicant's objections are technical and aimed at obstructing the production of material evidence. Reliance was placed on the Republic versus Principal Magistrate Court at Mombasa and another, ex parte Kitsao and two others, Kenya Law Reports, in the case of Joseph Hendricks Waso versus Republic, to submit that inquests are not bound by strict rules of evidence and that victims' families are entitled to meaningful participation. The family urges the court to dismiss the application and uphold the ruling of 3rd of September 2025 in the interest of justice. Having considered the application, the affidavits on record, the written submissions of the parties, and the applicable law, the court identified the following issues for determination: whether this court has jurisdiction under Section 363 of the Criminal Procedure Code to review, vary, or set aside its extempore ruling delivered on 3rd of September 2025, and whether the court is functus officio in respect of the ruling directing the production of the arms movement registers, and whether the applicant's alleged objections to the production of the arms movement registers were raised, and if so, whether the failure to record them constitutes a violation of the applicant's right to be heard, and whether the production and admission of the arms movement register as Exhibit 16A and 16B was unlawful, irregular, or prejudicial in the context of inquest proceedings, and whether the respondent's replying affidavit sworn on 29th of October 2025 is fatally defective for want of commissioning, and whether the applicant has established grounds for the court to exercise its revisionary jurisdiction in the interest of justice. The court begins by considering the question of jurisdiction. Section 363 of the Criminal Procedure Code empowers a court to call for the record of any case pending before it and to correct any irregularity, omission, or error in the proceedings. This revisionary jurisdiction, however, is not unlimited. The court must consider whether it has competence to review its own ruling, the production of exhibits in ongoing inquisitorial inquest proceedings. The ruling permitting production of the arms movement registered was delivered on 3rd of September during an inquest. It is well established that once a court delivers a ruling in the exercise of its judicial powers, it ordinarily becomes functus officio, so where clerical error, omission, or irregularity warrants correction. The court will rely on the case of Raila Odinga and 2 others versus IEBC, where the court held a court is functus when it has performed all its duties in a particular case. The doctrine does not prevent the court from correcting clerical errors, nor does it prevent a judicial change of mind, even when a decision has been communicated to the parties. Proceedings are only fully concluded and the court becomes functus officio when its judgment or order has been perfected. The purpose of the doctrine is to provide finality. Once proceedings are finally concluded, the court cannot review or alter its decision. Any challenge to its ruling on adjudication must be taken to a higher court if that right is still available. End of quote. The principle of finality is closely tied to jurisdiction. In the case of the owners of motor vessel Lillian S. versus Caltex Oil, where the Court of Appeal emphasized that jurisdiction is the foundation of judicial authority, holding that a court lacking jurisdiction must down its tools and take no further steps. Once a court reaches the limits of its jurisdiction and renders a determination, any further action is void for want of competence. This position was reinforced by the Supreme Court in Samuel Kamau Mashari and another versus Commercial Bank Limited and 2 others, 2012, where it was held that judicial authority flows strictly from statute or the Constitution. A court cannot arrogate powers beyond those expressly conferred. Judicial power is not only derived from law, but is circumscribed by it. Once exercised within its lawful confines, the court becomes bound by the limits of its mandate. Taken together, these authorities articulate a coherent doctrine of finality. Once a court has lawfully exercised its jurisdiction and made a determination, it becomes functus officio and may not revisit, vary, or reopen its decision unless expressly authored by statute of the Constitution. Absent from such authority, the judicial process must come to an end. This principle safeguards legal certainty, upholds the rule of law, and prevents impermissible self-review. The issue of whether the court is functus officio is therefore central. The applicant seeks review of a ruling made during an ongoing inquest, permitting production of the arms movement register. The court observes that the ruling followed submissions from the prosecution, IPOA, Law Society, IJM, and the National Police Service, and after the applicant appeared and testified as the lawful custodian of the registers. Where the applicant now claims that objections were raised but not recorded, the court demonstrates that this position was not fully presented through both testimony. The court finds, therefore, just a minute. The court finds, therefore, that it is not functus officio, and even if a minor omission occurred, it does not warrant review under Section 363, absent demonstrated prejudice, as it was held in Republic versus Magistrate Malindi Subordinate Court. The court has considered the applicant's claim regarding consent, chain of custody, and risk of tampering. The court record shows that Corporal Okapesi testified extensively on 3rd of September this year, explaining the procedure for issuance of arms, use of the correction fluid, and the circumstances under which entries were altered. He admitted that all corrections were made in good faith no firearm was lost, and the registers remained accurate. Cross-examination and re-examination confirmed that no unauthorized tampering occurred and that blank spaces were filled by him to prevent misuse. Therefore, this court finds that any alleged failure to record objections does not amount to a violation of the applicant's right to be heard under Article 50 of the Constitution, as the substance of his objections were clearly before the court. This aligns with the case of Republic versus Principal Magistrate Court at Mombasa and another, ex parte Kitsao, which held that inquests are inquisitorial and courts may receive evidence necessary for establishing the truth, even if minor procedural concerns are raised. On the lawfulness and regularity of the production and admission of the Arms Movement Register, the court is guided by Section 385 to 387 of the Criminal Procedure Code, which establishes that inquests are inquisitorial proceedings aimed at ascertaining the circumstances surrounding a reportable death. Section 386(1) empowers the court to summon and examine witnesses and receive such evidence as may, in its opinion, be necessary to discover the truth. These provisions deliberately relax strict evidentiary rules in favor of a broad fact-finding mandate mandated by public interest and transparency. In this case, the arms movement registers constituted primary and material evidence relevant to the inquest, detailing issuance, movement, and accountability of firearms connected to the deceased's death. At the time of productions, the registers were lawfully held by a POA under a prior court order, a fact not contested by the applicant. Their production was not capricious, but directed by the court in furtherance of his statutory duty. The applicant, as custodian, confirmed on oath that all entries were made by him and that no third party interfered. Allegations of irregular custody, tampering, or prejudice are unsupported by the evidentiary record. The court's power to admit the registers is further reinforced by Section 173 of the Evidence Act, which authorizes the court to summon and receive any document necessary for just determination, notwithstanding objections. While Section 79 to 82 of the Evidence Act govern proof of public documents, they regulate evidentiary convenience and do not oust the court's discretion in inquisitorial proceedings. Certification under Section 80 to 82 is permissive rather than mandatory. In the case of Maurice Ndo and Kinywa Mwelenga versus Republic, the High Court held, and I'll quote, "An inquest is not a criminal trial and is not conducted for the purpose of determining culpability. Its role is limited to establishing the circumstances surrounding the death. Courts may receive material evidence necessary to establish the circumstances of death, even where technical objections are raised." End of quote. Similarly, in Macau Musau 2024, the court stated, and I'll quote, "The process for an inquest is designed to be inclusive, involving all conceivable parties and all interested persons and or witnesses to the furthest extent practicable and as appropriate to contribute to the fact-finding exercise." End of quote. These authorities affirm that evidentiary provisions governing public documents cannot be applied mechanistically to defeat the purpose of an inquest. Regarding the respondents' replying affidavit sworn on 29th of October 2025, the court finds that any procedural defect did not occasion prejudice. The affidavit was largely responsive and did not introduce facts material to the motion. As guided by the case of Mary Gathoni and another versus Frida Ariri Otolo and another, 2020, the court exercises discretion to evaluate procedurally imperfect affidavits without striking them out. In conclusion, the applicant has not established sufficient grounds for the exercise of revisionary powers under Section 363 of the Criminal Procedure Code, and the inquest, including the admission of Exhibit 16A and 16B, was conducted within the law, with full opportunity for the witness to be cross-examined. The issue of the chain of custody is something the court has noted and will take into account when all the remaining witnesses will testify here. The upshot is that the application is hereby disallowed. These are the orders of the court.
Thank you very much, Your Honor. We would pray for a certified copy of the ruling for our record and perusal. This is Mwangi KM.
Mwangi KM. Can you introduce yourself since we are many? I cannot be able to get Mwangi KM. Okay. Yes.
Your Honor, Makori for the state. We also thank you for the ruling. Though maybe I may just add that an affidavit had actually been placed before you in open court, which was commissioned.
Yes. I was just relying on the submissions first.
Yes, yes.
Yeah.
Your Honor, Mwangi Chege, I thank you for the ruling.
Yeah, and last Souma, we welcome the ruling and will be praying for a certified copy of the same. However, in view of the comments made by Minority Senior Mr. Makori, should it be taken to be an approach or requesting you to amend you having made your ruling and probably become factors official?
No. But just a point of clarification.
Yes. I just rely on your submissions.
I'm most obliged, Your Honor.
Yeah, I'll just rely on the submission. Okay, I will give all parties will be given a certified copy, and also we can agree on hearing dates.
Your Honor, perhaps you could guide us on the hearing dates that are available to the court.
19th of February, 24th, 25th. In the afternoon, huh? All of them in the afternoon. Is it convenient, 19th, so that you can...
19th is convenient for the state.
It's convenient.
Convenient for import.
Mr. Mwangi Chege?
It is convenient, Your Honor.
Ms. Nicholas?
Your Honor, I will speak for her. It is also convenient.
Okay. Mr. Elias Uma?
You know, it's convenient if the prosecution can inform us the witness they intend to rely on.
Okay. So we agree first on 19th of February at 2 p.m. And is this a witness that can be heard online, virtually, or do you want to come to open court?
I believe this witness will come to court in open court.
Yeah. Okay, 19 is okay. So at 2 p.m. All of them at 2 p.m. Yes, we can check on 24th of February.
Convenient on our part. Is convenient.
Your Honor, it's convenient for the state.
Your Honor, it is convenient for the LSK.
So, Mr. Okay, we can go to 25th.
Your Honor, it's also convenient for the state.
I confirm it is convenient for us also, Your Honor.
So what we'll do, we'll serve the 3 days, that is 19th, 24th, and 25th of February.
Thank you, Your Honor.
They are all at 2 p.m.
All at 2 p.m. Yes.
Your Honor, could you repeat the dates?
19th of February, 24th of February, and 25th.
Most obliged, Your Honor.
19th being a Thursday, 24th being a Tuesday, and 25th a Wednesday. That's okay?
That's in order, Your Honor.
Okay, that's you. Have a good afternoon.
Most obliged, Your Honor.